All rise for the Honourable Chief Justice, John Marshall.
We will hear the argument of the case of Marbury v. Madison in this court today. Marbury, you may now present your case.
Gentlemen of this court, I have received a presidential appointment for the role of the Justice of Peace in D.C. However, Mr. Madison failed to deliver my commission and finish my appointment. I have reason to believe that this was done with malicious intent. Therefore, I am petitioning the court here today to issue a writ of mandamus to force him to hand in my commission, a power given to the court under the 1789 Judiciary Act.
Thank you, Counselor. Does the defense wish to issue an opening statement now?
Yes, sir. Simply put, I have done nothing wrong. The commission was supposed to be delivered by the previous Secretary of State. It became null and void the second I entered the role.
I see. The prosecution may now present their case.
Thank you, Your Honor. You see, here I have a copy of the presidential commission that would have given me my position. You can see where the president appointed me, where the Senate voted me in, and where the president came back, finalized it, and turned it into a commission. I would like to add this to Exhibit A, Your Honor.
Has the defense any objections to Exhibit A?
No, sir.
Very well. Evidence admitted. Proceed.
Secondly, I have here a recording of the defense with my commission, in which we can see how the defense handled this commission. I would like to enter this into Exhibit B.
Interesting. Have you any retort, defense?
No, sir.
The prosecution may proceed.
Finally, I have Exhibit C. This is an audio recording of the defense and future U.S. Senator Mitch McConnell discussing plans to not deliver my commission. No, seriously, I swear, it works like a charm.
Really? Just like that? I just don't deliver it?
Yeah, just don't do it. Trust me, it works like a charm.
Well, if you say so, pal.
Alrighty, well, I've gotta go.
Alright, love you. Mwah.
Love you too. I would like to enter this into Exhibit C.
I see. Well, has the defense any words about this?
No, sir.
Very well. Does the prosecution have any more to add at this time?
That is all, Your Honor. The prosecution rests.
All right. The court thanks you for your evidence. The defense may now present their evidence.
I will present my evidence as it is relevant.
Excuse me? Sir, that's not how this works.
Why not?
Because I am the judge of the Supreme Court and I say so.
Fine, then I have no evidence to present, Your Honor.
Well, if that's the case, then you cannot speak in this case because you have no ground to stand on.
Like, literally cannot speak. Like, as in, literally cannot speak.
Precisely.
Alright, fine. I enter the Constitution as Exhibit A.
Does the prosecution have any objections?
Yes, Your Honor.
Proceed.
Well, he cannot enter the entire Constitution. That's far too broad. How am I supposed to argue that?
Sustained.
Seriously? Well, how about, what about here? The first 3 articles.
Very well. Has the prosecution any objections to this?
No, sir.
Very well. Admitted. I assume that you have no more to add, Madison?
That is correct, sir.
Very well. The prosecution may now present their closing arguments.
Thank you, Your Honor. I was clearly owed the position, as can be seen in Exhibit A. I had gone through all of the legal hurdles, with the only step being to simply deliver the commission. Which, as we can clearly see in Exhibit B, my commission was grievously mishandled by the defense. This proves that the blockage occurred at the defense's stage in the election process. Finally, Exhibit C proves intentionality and malice behind the defense actions. Exhibit C is a phone call in which the defense clearly admits to this blatant misuse of his power. He admits to dragging out this ordeal and is even boastful about it, shedding any idea of remorse. And with this, the prosecution rests its final argument.
Very well. Thank you, Counselor. The defense may now present its closing argument.
You see, Your Honor, the commission is simply void and invalid since I did not deliver it. The final step in the election process is the delivery of the papers on my end, giving me the same authority over this matter as the Senate who voted them in. Therefore, you cannot make me.
Is that all?
Yes, sir. I rest my case.
Very well. I shall look over the evidence provided and make my decision. With the evidence that has hereby been provided to me, I find that Marbury's petition to this court for a writ of mandamus to force Madison to deliver the commission is valid. This is in accordance with the Judiciary Act of 1789. However, I find that in accordance with the Constitution, the Judiciary Act of 1789 is unconstitutional, and therefore, the Supreme Court of the United States does not have the right to issue such a writ. Therefore, we cannot make him. This court is adjourned.